Troy Rawlings from Davis County, Utah. He is in his fourth term in that office and has also developed a community advisory board, but for an entirely different purpose. And he is going to join us again. You should look at his bio in the booklet. He has done many trainings and has spoken on TV about many different topics. So he is really going to be a very interesting speaker about his community advisory board. So I turn it over to you, Troy. Thank you so much for joining us.
Thank you very much. And hopefully I'm sharing the right screen. Does it look like it is on your side? All right. I appreciate
yes. It's if you could put it in the presenter mode, then that would be great. It's there you go. Excellent.
All right.
Thank you.
And first of all, I'm very heartened by this discussion so far today. I'm glad to be a panelist because that means I'm also a participant. And I got to hear what Gene Peters Baker had to say, and Brian. Their focus is a little bit different than what we've done in my county. And so I've been educated on what they're doing. And I think I'm going to incorporate a lot of what they're doing and try to move in that direction as well. As you indicated, we've done it a little bit different in Davis County, the jurisdiction where I'm the elected district attorney, and I'm on my fourth term. We just had to file for re-election last week. I did not have an opponent this time, so I guess I'll be elected for a fifth term in my jurisdiction. So I'm heartened by that because I love this job for a lot of reasons. Justice is a passion of mine. I went to law school to be Perry Mason, to be a defense attorney, went to law school in Alabama so I could defend all the people that are wrongfully accused. And what I learned after being a defense attorney for 6 years is prosecutors are really the ones in our system who have the keys to justice. So I can be the best defense attorney I can possibly be by being a prosecutor. I take that seriously. One of the standing jokes of a former sheriff about me was that we have a defense attorney for a DA. And I actually embrace that because that's part of our role, I believe, as prosecutors is, while we're protecting public safety, protect the constitutional rights of those who were investigating and prosecuting. And that dovetails into exactly why we did what we did, I think, in the presentation I'm going to be making to you today. But we have about 355,000 people in our jurisdiction. As you can see, I have 19 prosecutors in the Davis County Attorney's Office, including myself. I actively still prosecute a caseload, even though I'm the elected, just because I have to. The numbers we're pushing, we have about 8,000 cases a year that come to our door for screening. About half of those are felonies, some mixed with misdemeanors. The other half are just straight misdemeanor cases, as we do some justice court and municipal prosecution for some of the cities. But that 8,000 cases is kind of a daunting number. I have a concern to make sure we're handling them properly and appropriately. We have about 15 homicides a year, not a lot comparatively speaking to other jurisdictions, I'm sure, like Gene's jurisdiction. We have our share. We have about 500 child sex offense cases a year, about that many child physical abuse cases, about 600 DV cases that come to our office. So a lot of the cases we deal with are serious in nature. I mean, every case is serious to the defendant and the people whose lives are involved in it. But we take our role seriously. We understand in our office that the decisions we make impact people's lives. So we always want to make them better on more information rather than less, and use all the tools available to us to do it. So because of that and our role of prosecutors and the number of cases we push, I'm concerned about the quality. I want to make sure we have good quality control. So we have various procedures in place. But one of the things that became important to me and the focus that we did with our community was to set up a conviction integrity unit. So we've focused on that first. Although I love what Gene and Brian have outlined, and I'm going to be focusing on those type of community organizations next. But ours, in addition, we have a Citizens Academy that meets quarterly. Citizens Academy are citizens that we educate along with our 13 law enforcement agencies on what's going on in the community. We do get some feedback from the Citizens Academy, but it's not formalized like what Gene and Brian have. But what we do have formalized is our conviction integrity unit. So one of the ways we went about establishing and setting that up in Davis County, our conviction integrity unit, was we got some legislation passed in 2020. We actually started looking at doing this, as all of you are probably familiar to a large degree with what they are. But around the country, other jurisdictions were doing this. I like the idea a lot for multiple reasons we'll discuss today about setting up a conviction integrity unit to review our work in our jurisdiction. But one of the things that did concern me was I kind of didn't necessarily want to be just totally ad hoc. So we actually in 2020 worked with legislators, got an enabling statute passed that sets the fence posts, the guidelines, the role of conviction integrity units when you formalize them in the state of Utah. Salt Lake County beat us to the punch. They set one up first. But we soon followed thereafter. I think there's now 4 conviction integrity units in our state. We actually commenced formal operation last November of 2021 after a significantly long process, probably comparatively speaking, in getting it up and running. Because one of the things that I knew in advance was I didn't want this, folks. I didn't want the conviction integrity unit that's set up by the Davis County Attorney's Office to be viewed as an extension of the Davis County Attorney's Office. It was critical to me that our community, everybody from the defense bar to the citizenry to the judiciary, realize that this is a serious unit. It's independent of the county attorney's office. Yes, we help establish them. We coordinate, we facilitate information to them, but we focus then when we set it up on establishing a unit when we did our recruiting as to get that ideal, to basically have an exhibit of independence that was accepted. We started meeting then. One of the linchpins to setting up our conviction integrity unit was getting the right person involved as we started our recruiting. We started meeting with Judge Glenn Dawson. So one of the first, I think maybe the most important and significant decision that I made was who is going to chair our conviction integrity unit, because we don't. It's outside of our office. It's independent of our office. It was set up and established by our office. But I picked somebody to be the chair and approached Judge Glenn Dawson. Judge Dawson is a retired judge in the state of Utah. He was a former federal prosecutor, and then he was a district court bench judge for years in our county. He was well respected in the community. He was well respected by the defense bar and the prosecutors. Judge Dawson was the particular judge that you all wanted. When you try cases, he's the guy that you hope you get the case, particularly if it's serious or significant, because he had a great ability to make evidentiary rulings on the fly. He understood the rule of evidence, how they applied. He was fair. And he was definitely not a rubber stamp for the prosecution or the defense. Judge Dawson was truly one of those judges where you know that the ruling you're going to get is going to be based on the facts, the law, the evidence, and whether it's a defense-friendly ruling, a prosecution-friendly ruling. He was fair, he was even, he was across the board. So after he retired, this was the judge that I reached out to, that I realized that the chair of this unit was going to be key in a lot of ways, in establishing the policies and selecting the rest of the members of this unit. So everything was that we go from there. I think the linchpin was recruiting with Judge Dawson. We got him involved. Judge Dawson came on board, and we started meeting quarterly for about a year. And it took that long because what we were doing then specifically was deciding who we're going to recruit and reach out to individuals that we wanted to be part of our conviction integrity unit. We set some criteria. I did, but my primary criteria, besides my ideas, was letting Judge Dawson determine. So I established some general rules as to things I wanted to see with this conviction integrity unit. We set the number at 9. So we have 9 members of our conviction integrity unit, much like the United States Supreme Court has 9 members. We wanted 9 members because we wanted some breadth and some diversity. Part of the problem we have in my jurisdiction, folks, I will tell you, I probably am the elected district attorney in maybe the most Caucasian, the most homogenous jurisdiction in the country. We are just north of Salt Lake. Most of the people in our community work in Salt Lake, but it is primarily a very Caucasian, upper class community. We do not have a lot of diversity in every way you can imagine. There's not a lot of religious diversity or ethnic diversity, racial diversity. So we're pretty homogenous. But I wanted to do as good of a job as we could with I guess the demographics that we have of reaching out. So in our selection and recruitment process with Judge Dawson, one of our criteria was we wanted 9 people, ultimately. We wanted as diverse as we possibly could get, and I did not want it to be a prosecution-loaded, prosecution-based group. So we wanted a variety of perspective and background. I did not want it all to be people that were legally trained. So we didn't want it, just completely loaded down with those who have worked their whole career in the legal system, although we did want some people who had shown some interest in that. So as we were recruiting and setting these requirements and setting the parameters, Judge Dawson developed a list of names in conjunction with myself and others in our office. We consulted our public defender coordinator, Todd Etzinger. We consulted the private defense bar to get lists of names. We kind of put it out there as to those who wanted to be involved in this. And then we let Judge Dawson, who was the chair, the appointed chair, Judge Dawson actually did all of the interviewing himself. I stayed out of that process. Because again, I wanted this to be as independent from me as possible, because this group of citizens is reviewing the cases that come out of our office, the cases that we prosecute, that we screened, that we filed, that we took to court, that we took to trial, or even if there was a plea resolution. So I truly wanted the group to be as independent from me as possible. So that's why we allowed Judge Dawson to be the one, along with the criteria that we kind of established. Judge Dawson is the one who then did the interviewing and the vetting, and the group that we ultimately came up with the selection process was those who had some either expertise or background in criminal justice, but also those who didn't, but who had exhibited an interest in the system. And so we ended up with 3 defense attorneys. There are no prosecutors, by the way. We don't have any prosecutors on the panel. One of the defense attorneys was a prosecutor early in his career, and then spent a lot of his career then as a defense attorney. So he went back and forth. But we have 3 defense attorneys, 2 judges, Judge Dawson, who was a trial court judge himself, and then one of the better appellate court judges probably the state of Utah has ever seen, Judge Stephen Roth. So we have both that background, both the trial court and the appellate court bench on it, and then 4 at-large community members who have a diversity of perspective and background, both politically, philosophically. We have some that are more on the left, definitely, some more right of center. And we wanted this group, and they've melted together well. They then started having meetings. They started having their first meeting before we formally launched with a public announcement November 1st of 2021. But they started meeting earlier in 2020 to establish their policies, to vet the policies. We pulled for them conviction integrity unit policies from all around the country. We borrowed Salt Lake, San Diego, Los Angeles, various places that had conviction integrity units. So we gave to Judge Dawson and the group a whole bunch of different policies they could use to look at, to model from. Judge Dawson and his team then began a series where they were meeting, and they did a combination either online or in person, whichever they wanted to do. If they felt comfortable coming in person, they would meet in our law library, or they would meet online. They developed their own policies and procedures that we have now published on the website, along with the bios of everybody in the conviction integrity unit, and set up how they were going to go about doing it. And so it became important for us to have a mechanism, a procedure that was fair and balanced with the prosecution and with the integrity unit. As you all know, the prosecutor's job is to protect the innocence of individuals before, during, and after trial. So we wanted to set this group up as our after trial tool. So this group is separate. Obviously you have the appellate system already. And one of the things that I wanted to make clear that we do with this group that's different than just an appeal, first of all, somebody has to have exhausted their appellate remedies to take advantage of being able to petition our group for this post-conviction review of their conviction. So once the appeals are all run, their post-conviction factual innocence type petitions that they can do, they can then petition this group. And one of the things that is different about this group that we set up in policy and procedure is they can actually do their own investigation. So this is not just a group that can only do a paper review like a court of appeals and look at the record. This group, once they get a petition and they review them, they vet them, if they decide that they're going to accept a petition, that the criteria is met, that the individual who has petitioned has raised some issues that they're willing to look at, they then get the complete record from our office, from the court, but then also they have the freedom, and we will fund it out of the Davis County budget. If they feel like that they need to interview people, they'll get waivers signed by the defendant. As part of the process, the defendant will sign a waiver of attorney-client privilege, so the unit can interview the defense attorney if they need to. They can interview, reach out, and of course, they're not necessarily going to compel people to come, but interview witnesses, interview the trial court judge. So this group actually has a much broader mandate and ability to operate and proceed than obviously the Court of Appeals does, because we want them through their process to be able to come to the best decision possible. So the statutory process is set up, and one of the things that the statute indicates is if we set one up, once it's done, that I, as the district attorney, can accept their recommendation or I can reject it. One of the things we did by policy, though, because I'm so serious about this group and being legitimate and having confidence, and want the public to have confidence in this body that it's real. This is not just a group that's set up to rubber stamp what we have done. I actually put in the policies and procedures, had Judge Dawson put this in there, I will accept their recommendation. So in other words, if this group determines, so I'm bound by the policies of our conviction integrity unit. So we're the only one in Utah doing it this way. The other 3 who have set it up, they're following the statute, which is fine, that the district attorney then can review their recommendations and can either accept it or reject the recommendations. I didn't want to do it that way. So one of the significant changes we made to our policies was I agreed. Now, the next district attorney after me probably could change that. They could go back to the statutory language that they accept the recommendation. But I'm serious about this, and I want this group basically to be legitimate. I want them, the group themselves, to understand that the work they're doing is important and it's meaningful, and come to the best decision that they can, put the time, effort, and energy into it, and realizing that the decision they make matter. So the way we have set it up is they get a petition, then they have accepted one already. They have accepted one, and they've reviewed it on a serious case, an aggravated robbery, burglary, and rape case that they've been putting time, effort, and energy into vetting it. But once it's done, then what they do is they release to me the vote, and they'll give me the number. If it's 7-2, 9-0, 5-4, but whatever the majority vote is the decision of that panel. And if the panel votes 5-4 or 6-3 or whatever to overturn the conviction, then I will accept that. And the next process in our statute is I then file a petition with the court in which the conviction was entered. And we then take that to the judge with the findings of our conviction integrity unit and file a petition asking the court to then vacate that conviction. In the one that we have had so far, they made a unanimous finding 9-0 not to vacate the conviction. So the conviction was left in place. We've had 3 additional petitions filed that they haven't had a chance to vet or review yet. But that's the process and policy and procedure that they go through. They have a lot of authority. We give them the budget to do it. They have the mandate to do it. And then I will accept the recommendation that they come up with. I guess one of the biggest lessons that I learned during this process of lessons learned is there was a reluctance. When I first announced we were going to do this, I had to overcome some reluctance of law enforcement and even prosecutors in my own office. What are you doing? We already have an appellate process. This is going to be costly. It's going to be time consuming. It's going to cause another layer of stress for victims. You're going to be putting, and some of those, I guess some of that is true. This is another opportunity for defendants to seek review of their conviction. And when they do, part of the process, the victim is notified. If a petition is filed and our conviction integrity unit determines that they're going to review that case, then victims are notified that this is going and it's in place. And so I guess one of the biggest lessons I learned was this did cause consternation among victim advocates. They didn't particularly like that I was doing this among some of the prosecutors and among some of the law enforcement. Bottom line, how do we overcome that to the degree we can? Just educate them on why we're doing it. That as prosecutors, our overall mandate is to try to get it right, not just be right, not just be vested in just because we've got a conviction. We shouldn't be doubling down that we were right. We should be using all the tools at our discretion in the arsenal to make sure that we got it right. And so this independent outside review board that can look at it and can have confidence, then give us confidence in our work. It also kind of serves, maybe, believe me, all the prosecutors in our office know that we're doing this, that this group is there. We made a big deal. We made a public announcement. It also hopefully serves as a check and balance, not that we have problems in our office, but if the prosecutors in our office know that their work can be reviewed by this outside panel now, not just the Court of Appeals, limited to the record, so we can get into issues in this, like Brady issues, Giglio issues, all of those things are on the table for this conviction integrity unit to look at. They can not only look at the substantive conviction, they can look at the procedure and the process that was done. If they feel like constitutional rights were violated, where all of our discovery obligations met, it's all on the table to be looked at and reviewed. And I think one of the benefits of that then is, since our prosecutors know that, law enforcement knows that, I've had meetings with the police chiefs throughout the county explaining this to them, why this is now an important another level of review. Hopefully some of the benefits are that the investigations are tighter because our prosecutors are now seeking additional follow-up. Maybe they're preparing for their cases a little bit better because they realize that this conviction integrity unit is now there as another independent check and balance on how we as prosecutors do business, on how we do our jobs. So hopefully that will be some of the benefits and byproducts. I think the initial benefit that we've already obtained is it's been overwhelmingly a positive reaction from the community. As a matter of fact, I've been told that one of the reasons that maybe I don't have an opponent in this election cycle, there were some who were thinking about running against me from the defense bar, decided not to because they feel, hey, the community has received this so well that our office, the prosecutor's office themselves, is interested in making sure that they got things right, that they've set up this independent branch or division that can review basically de novo everything related to a case on cases that meet the criteria for them to accept, and that I'll accept their findings and then file the petition with the court. So it seems to have really resonated. The support that we got after the press conference from the media, from the public, things I heard recently at conventions, it's all been overwhelmingly positive. But so again, the only momentum I had to get was overcoming maybe some of the initial opposition of prosecutors, victim advocates, and law enforcement. But hopefully they'll come to embrace it and realize that as we incorporate best practices in how we do our business, that maybe then it incorporates better practices on their end too, in what they do, and leads to hopefully the results that we all want in cases, which is justice and not making mistakes. And I think that that's the biggest benefit. Is really just another level, another way to ensure that we're doing our job right and not making mistakes.
You have 5 minutes left.
Thank you. As far as tips for smaller jurisdictions, we're lucky in our jurisdiction that we've got the size and resources to do it. We actually reached out. So not everybody on our conviction integrity unit lives in our jurisdiction, lives in our county. As a matter of fact, the law professor that's on it, Tanil Brown, she lives in Salt Lake County. A member from the ACLU that was an attorney and a defense attorney, Marina Lowe, excellent attorney. Marina Lowe lives in Salt Lake. Judge Roth lives in Salt Lake. Adrian Andrews lives in Weber County. So we reached outside of our own jurisdiction to find the best people we possibly can. So I guess it's a tip for smaller jurisdictions. I know one of the things in Utah they're talking about doing is combining conviction integrity. Some of the smaller counties in Utah that don't have maybe the resources that we do, they're talking about maybe doing it on a district-wide basis, or combining maybe a 3 or 4 county conviction integrity unit where they can draw from a bigger pool and maybe combine resources to do it. Also do what we did for smaller jurisdictions. That's we borrowed. We didn't sit down and invent the wheel. We took a look at good policies and procedures that were already in place from other jurisdictions as to what they were doing that beat us to the punch on this, and gave those to Judge Dawson. And so they had a model to look at, and they took basically what they felt was the best from multiple policies and procedures from around the country of CIU units in combining and deciding what they're going to do for their policies and procedures. So those would be some of the tips I would have for smaller jurisdictions, is maybe combine and pool resources if that's possible, where you're at. That's what's going to be done in Southern Utah. We have a lot of smaller counties. They're going to combine, and they're going to have a Southern Utah conviction integrity unit that is going to be a combination of multiple jurisdictions combining and pooling their resources to do it. They've asked me for our policies and procedures. We're giving them those along with the copies of all the other ones that we use to vet ours from and put ours together from. And so hopefully that will help jumpstart them. And then we do have a statute in place that outlines how to do it. So there are some guide rails. And so maybe that would be another way to do it, to borrow like statutes of states like Utah that have an outline already how to do it, so you don't have to start from scratch. Our statute is pretty good, and if anybody wants that statute, it's linked. It's on our website for our conviction integrity unit in Davis County, so you could look at the Utah statute. But basically, that's my best suggestion: is don't feel like you have to invent the wheel from scratch, because you don't. If you want to do a conviction integrity unit, there's a lot of material out there, statutes and policies and procedures, and you can combine and pool resources with other jurisdictions if you need to. So it looks like I'm probably close to being done on time. So there you go.
Well, thank you so much, Troy. I really appreciate it. I should note that PCE has written a national guide on conviction review units that has some information, and we will circulate that to the people who've registered for the call so they can have the benefit of that as well. Your model is a very interesting one, particularly because you are allowing the panel to make the final decision. I have one question for you before we turn to our breakout groups. Would you consider using this panel for other types of things other than conviction review?
We would, and we actually have had that conversation with Judge Dawson about some of the things that they might be able to do. Here's the only drawback on that right now. I love that idea. It's their time. And it is the fact that they're not paid. I should have mentioned that to everyone that's doing this is volunteer. They're putting their own time into it. So these are serious people, all of them. And now Judge Dawson, Judge Roth are retired judges. And so they probably have the most time. Everybody else, like the defense attorneys, are still currently practicing defense attorneys. And so the issue is just the limitation that we want to put on this particular group with their time. So what we've decided to do with that is we're going to go through the first year, see how many petitions they get, how much time it actually took, and then make a determination as to some of the other ideas we have as to what we can add on to their plate. Interestingly enough, to dovetail into what Brian Porter said, one of the things that I've asked the judge to consider if they feel this group has time is to make policy recommendations for our office, review the policies of our sheriff and law enforcement throughout the county, review our policy and procedures manual, and then maybe legislative issues too that Brian mentioned. If they can make recommendations to us as a group as to we can send them proposed legislation throughout the year, and those sorts. So we would like to tap into them if their time allows. But for right now, the logistical problem is the practical problem is they're unpaid, and some of them are still working professionals. Only 2 of them are currently fully retired.
Yeah, that is a big obstacle, because doing a full-blown review, which is what you've tasked them to do, can be very time-consuming. But we look forward to hearing how it goes. How long have they been how long have they been put together? When did they start as a team?
They November 1st, 2021 was the official formal launch. They were working together on the policies and procedures for about 9 months before that, though. Their first meeting was February of 2021. They spent those months formulating the policies and procedures, deciding how they were going to operate as a group. But their very first meeting to review a case was November 1st of 2021. They actually took 3 months too. They took 3 months to review the first case that was petitioned to them. It was a serious case. Like I said, multiple first-degree felonies here in Utah with life sentences. They put an awful lot of time into that one case. I'm just like blown away, in awe of how much time they put into it, and the decision that they made, and the quality of the reasoning of the decision was phenomenal. That's why if they tell me we need to overturn a conviction, I'm going to have confidence in this group. I think they're going to get it right.
Thank you very much.